live, yes.
Okay.
Yes.
Just a very quick update, not related to this bill, but to the data bill.
Okay.
I did speak to Director Davis, and she said that she would be happy to come back and help clarify the discussion that we were having at the end of that session.
Great. Okay. Thanks. We'll work on finding time for her. Thank you for that update.
Great.
Okay, thank you. So we are now going to transition to H629, an act relating to access to adoption records, House Judiciary Committee. And before we start with our witness testimony, I did want to just talk about our process a little bit, because we have heard from some folks in state and out of state, and certainly whenever this committee, or I think just about every committee in the legislature, works on a bill, it takes more days than one. So I heard concern that we have finished our deliberations and have finished with the bill, and in fact that's not true. That 1 or 2 days is very rare for us to be able to finish a piece of legislation, especially on a topic like this. The other thing is that very rarely do we pass a bill as introduced. It's a starting point of a conversation, and that's why we have testimony, to work with the bill from as it's introduced and to hear from a diverse number of voices. And as one of the sponsors of this bill, I can say for myself that I don't agree with it. I don't think it goes far enough. And it certainly it's not in terms of where I would like to see the discussion and the policy go. I would not want to pass this bill as is. And so, but again, we're having witnesses and we have committee discussion, and we will see where it goes. But I did want to clarify that for the record. So with that, I would like to welcome Attorney Luce. If you could please introduce yourself for the record, and thank you so much for being available.
Thank you, Madam Chair. And my name is Gregory Luce. I'm an attorney. My practice is in Minnesota, but I represent intercountry adoptees all over the country on issues of U.S. citizenship. But I also represent domestic adoptees, predominantly in Minnesota, who are having issues getting their identity documents, specifically their original birth records. I'm also the executive director of Adoptees United, Inc., which is a national nonprofit that is dedicated to equality for all adopted people. So I'm considered, I kind of fell into being a national expert on this issue, but I think I can accurately say that I am. And I really do appreciate the clarification on how the committee works. It was new to me to have a number of hearings on a bill and to see experts and also those impacted testify over a number of hearings. And I'm so used to one hearing and you're done, and you fight as much as you can for that one hearing, and then you sort of throw it up in the air and see what happens. So it's nice to have such a broad discussion and have so many people testifying on a bill that means a lot to, I can certainly say, to adopted people. So I know that one of the things I believe this committee is interested in hearing. Yeah.
Excuse me.
Just for clarification, I think you just blew me away with your statement. So potentially in another state, there could be the same exact bill, say, and you would go in for, I'm going to guess, an hour or two tops for a hearing, and then the decision is made on which way to go with the particulars of the bill?
Yeah, it's pretty much, and it's one hearing in each of the chambers in New York, actually, and then it's a law that passed in 2019 and went into effect 2 years ago. There was no public hearing except for like 5 or 6 years prior, but on the bill that actually passed, there was no hearing whatsoever, other than the committee got together and made their statements, but no one testified. So I think you are unique in this approach.
Wow, it makes me feel pretty good about our process here in Vermont.
I mean, I like it. I really do like it because you know, and I think you got probably a lot of pushback from people who thought it was one hearing and we're done. You know, and I got a little up in arms about that as well, but it turns out that that's
Sure,
not how
sure.
you do it. Yeah.
Huh.
Okay, yeah, thank you.
Yeah, I mean, regardless of the topic and where somebody would fall in their belief or principle on the topic, yeah, I would have a lot of trouble with that myself. So,
Right. Well, it's good to be here and be able to shed some light on our views on the bill as well. But I think one of the things that the committee is interested in hearing about is what other states are doing on this very specific issue, especially the states surrounding Vermont. I've submitted a number of illustrations, some national illustrations, but including one that shows how the New England region and the state of New York handled this issue today. Currently, Massachusetts and Vermont are outliers in restricting an adopted person's own birth record, though Massachusetts is pretty close to removing that restriction entirely. All other states in this region provide an adult adoptee who is at least 18 years of age, and some they provide it to descendants, a copy of the adoptee's own pre-adoption birth record without restriction, and I could say without any incident I'm aware of. I've submitted the graphic to help the committee understand how Vermont sits next to its neighbors and how much of an outlier it would be if it continues its current approach, even if the approach is adopted from H629. The three things I hope the committee would understand about this issue at its core are these. One, to separate search and possible reunion from a person's own vital record. The issues addressed by current law and by amendments in H629 are not the central issues for adopted people. The issue instead is a right to request and obtain a copy of your own original birth record without restrictions. What we do with that record is up to us. Some search, some already know all the information on it, and some people simply file it away, satisfied their birth, their actual birth, has been acknowledged and verified by the state of Vermont. This right to possess your own birth record is a right of all Vermonters, except for people born and adopted in the state. 2, separate the issue of birth parent privacy from alleged birth parent anonymity. Today, and even many years ago, there's no such thing as anonymity related to someone else's birth. It is a misnomer, likely generated in the context of private adoptions involving adoption agencies whose workers claim to a birth parent that, quote, no one will ever find out. That was untrue. It's wholly untrue and misleading to the birth parents. The tools have always existed, especially if you had the means to find out who you were born to. DNA is just the latest inexpensive but highly effective tool to do that. Importantly, adopted people understand privacy like all other Vermonters. We are not existential threats to birth parents nor to anybody else, though we are constantly treated that way. We are instead the living experts on how to handle the relationships, if any is sought, with our biological relatives. We know and live the navigation of complex biological knowledge, but only if we are ever given that knowledge. In fact, close to 100,000 birth records have been released in at least 10 states to date without reported incidents. The world has not fallen apart, lives have not been ruined, and especially when the truth of a person's own birth is given to that person. 3, and this gets to H629 specifically, which uses the current adoption registry system to facilitate communication between biological families. But a registry is not a vital record system, in the same way that an adoption record is not a vital record. They are distinct and separate. Pre-adoption birth records, or the original birth record as we call it, in Vermont and across the country, are sealed only after the finalization of an adoption. If there is a relinquishment or a termination of parental rights, but no subsequent adoption, the original birth record remains available to the registrant upon request. If a birth parent is under the belief that they cannot be found or known because they relinquished a child, they have been lied to. That child may not ultimately be adopted, or in some cases, an adoption may fall through. Again, the record is available upon request. More specifically, Vermont adoptive parents have the absolute right to request no new birth certificate be issued after an adoption. That's a law that's common in many states across the country. This is not a decision by the birth parents to seal a record. It's not a decision by the agency or even sometimes the court to seal a record. It is up to the adoptive parents. So when we hear about birth parent anonymity and their alleged control over release of a birth record that is ultimately not their own birth record, it has no support in the law, and it never has. It is a myth, but is a deeply embedded myth adoptees have had to fight against every time we come before a legislative body like yours. So we ask you to look hard at the current approach and work to separate the state's adoption registry, which is predominantly about search and reunion between biological relatives, from the vital record that is at the heart of this issue. This issue is not about searching for relatives or even contacting them. It is about the inherent dignity of adults to possess their own vital records. What they do with those records is up to them. But it is their record and their truth of their birth, and the state at its core must trust its own residents with those truths, as New York, Maine, New Hampshire, Connecticut, and Rhode Island already do. If I were to make an ask to this committee, it would be to hold this bill and allow Vermont adopted people and others who want to work on this issue to establish a working group, similar to what happened in New York, and work to hash out how to address the issue of a person's own birth record. I think the group would come to a solid consensus and on a resolution that would work. And I'm open to any questions about what's happened across the country.
Thank you. It's very, very helpful. And we do have another bill, we call it our wall, and you can't see it, but we have a bulletin board with all the bills that have been referred to our committee and the numbers. And every committee calls it their wall. And we do have another bill that Representative Webb introduced or sponsored last year that does have a study committee. And
I saw that.
Right. And my thinking was, well, let's put something in, let's have a discussion, aim high. But if that's not the right process, or, depending upon testimony, certainly we could do a study committee or something like that, which is, which we do, quite often. So thank you. Appreciate that. Your testimony. Questions? Oh, I'm sorry, Barbara. Go ahead. I didn't see your hand. There you go.
Thank you. So thank you so much for your thoughtful testimony. I have two questions. The first one is one that got raised after our hearing the other day. Somebody asked me about the safe haven law, and so you may know how this type of law, if passed, would fit in with safe haven. Because if it applies to safe haven, we no longer have a safe haven program as we know it. And if it doesn't apply to safe haven, I'd be curious if it would end up generating more people who would choose to drop their baby off if they were nervous about sharing information.
Sure. So generally, it would this depending on what law you're talking about, whether it's H629 or a different one, typically they're separate from safe haven laws. Safe haven laws are rarely used. I mean, the statistics are pretty low who uses them, and also typically a original birth record is not generated out of a safe haven relinquishment because there is no parent listed on whether it's a foundling certificate or whatever the state calls the certificate that's actually issued. I know that adoptees don't like safe haven laws, but they're in every state in the country, and I don't think they're going away. What we have often talked about with respect to safe haven laws is that if you have a hospitalization birth and the hospital is required to register that birth, that certificate be available at age 18 to the registrant or the person who was born. That's where I've come in some states to testify, to make people aware of how the birth certificate is affected by safe haven, but also if you have a registered birth with the names listed, that should be available either by court order or at age 18 for the person who was born. But it would not, the safe haven laws generally, to answer the question more directly, is they would not be affected by laws that release a record to the registrant upon reaching age of majority. Whether that increases the use of safe haven laws because this information would be found out, I would doubt very much in future relinquishments, because we have DNA now, and everyone knows that they're going to be found out no matter what.
Good point.
So yeah.
Okay, so here's my second question. It seems like we have a finite group of birth parents. So I was the other day when I was trying to think about this bill, I was thinking, okay, it's probably people who were born sometime, let's say 19. So I'm thinking about birth parents. So born like 1920s, if they're alive. I mean, I'm trying to think of who is alive now.
Right.
And up until we changed the law, and it was clear when somebody was adopting what the rule was. So probably between, let's say, 1920 and 1975. Is that right? That we're looking. It's that.
Yeah. So
bracket.
Vermont sealed their records and made them unavailable in 1941. So we could start with there if you want, to
Okay, all right.
1941 to mid 70s, maybe, when more open adoptions became the norm. I don't know. Yeah.
So like, here's what I'm grappling with, and I'm really, really sympathetic. I'm so sympathetic to both sides. We made a legal agreement or promise, and I know you say maybe we shouldn't have made that promise to birth parents that we wouldn't share that information back in 1940 or whenever. And so now we would go back on that. Like, I'm just wondering, like, I can't visualize how, if I were having that conversation with the birth mother or birth father, what I would be telling them. And if there should be some, given, I don't even know how many there are, and we probably could figure that out. Christina probably could quantify that number for us, maybe not. That's why we need more data resources in our state. But so is there a special way that group of people should be addressed? And, I like your idea of like, get everyone together and figure it out. But short of that, any thoughts?
Yeah, I have a lot of thoughts, and I don't know if I could summarize them all well in a short amount of time. But let me go back a little bit and say that this issue of a promise or a breaking of a promise is much more complicated depending upon what records you're looking at. And what I tell people all the time is, like, we have a large variety of records that are at issue here. You have the vital record, which is the birth record. You have the court records, which have a little bit more information and may have more confidential information than a birth record. You have the agency records, which are highly confidential, typically. I mean, the child placing agencies are heavily regulated not to release those records. You have maternity home records. You have hospital records. And so when we're trying to pinpoint where a promise was, we can certainly pinpoint there was not a promise related to the birth record. It was sealed, but it was also could be sealed or not sealed on behalf of the adoptive parents. Or it was never sealed, even though there was a relinquishment, so it was always available. So that promise of a birth record that should be always sealed for eternity is a false promise. Now, if we're talking about a promise of a social worker in an adoption agency saying, listen, what you tell me here about what you're going through and your circumstances, that's confidential, and I can't reveal that to anybody. We're not talking about those adoption agency records and that very private information. So I think it's really useful to make sure which records we're talking about. And for adoptees, for the most part, we're always talking about the original birth record, which has what we hope to be our factual basis of our birth. Sometimes it's not correct information on the birth record itself, but that's what we're talking about. There was no and never was a promise to keep that sealed. You can't. I mean, you can't promise that because of the way the law is set up. You can in other circumstances. Like the court has, control over its own records as well. So, and then get to the second part of the question about, well, what do we do for this? What we believe is a finite group of birth parents who very strongly believe that they would never be found, or they were somehow promised that they would never be found, I'd give control back to the birth parents on that issue. And in some states, I'm not sure if it'd be something adoptees in Vermont would agree to, but they may, is to have a contact preference form. And a contact preference form, Maine has one. I believe Rhode Island has one as well. And a contact preference form is up to the adopter, the biological parent, to file. And they have control over what kind of contact they would either prefer to have or not to have. It's optional. It's not binding, because you can't really control the knowledge that exists outside of this system. But they can also, but it's very useful information for an adopted person to get a contact preference form in which the birth parent has specifically said, I do not want to be contacted. We take that very seriously as adopted people. We don't show up on people's doors. We really don't, although the myth is that we do. And so that would be one avenue to explore. Whether you can find out within the registry system, and maybe Ms. Schuma could talk about this, what the finite numbers are, and can you identify these birth parents who have in the past, filed the disclosure veto, that's what we call it, and make them aware of the change and that they should fill out a contact preference form. That I don't know. I think that would be something worth studying.
Thank you. Other questions, committee members?
Can I just
Yeah.
ask a clarifying? Hi, this is Kate Donnelly. I'm just trying to familiarize myself with how this process works overall, and I just want to understand your testimony clearly. So, my understanding is the bill as written is really like framed as a directive towards the registry. Are you suggesting that you would prefer to see something that is framed more directly in terms of accessing vital records? Is that what you're
Yeah, I think it's a simpler bill to address only the vital record. I think you leave the registry to do what it does best, and that is facilitate communication or facilitate contact if contact is wanted between the two parties. That's essentially what's happening in Maine or New York. They have unrestricted right to the birth record, but they also have a registry on the side that people can use if they feel like they want some help in finding people or communicating with people. So yeah, I think it should be more directed at a vital record and much simpler in that way than using the registry as a vehicle to essentially control the release of information.
Thank you. That's helpful.
And committee members, we do have the graphics, the charts that Mr. Luce submitted, which I think are very helpful. I very much appreciate them. Yeah.
Can I ask a follow-up
Sure, yeah,
question about that? Actually, I was looking at those maps, and I don't know, it was pretty striking to see, and I guess I wasn't sure if you know more about sort of I don't want to take us down a rabbit hole, but sort of like the legal history of why it was such a dramatic shift. It was just was it just purely sort of like cultural sort of norms shifting around adoption, or like why did it go from green to all red? And it's pretty alarming.
It is. It's very alarming for adopted people. It's a great question. Originally, California was the first state to do this, to seal the record and make it unavailable to adopted people even when they were adults. And they did it because of concern of blackmailing of adoptive parents. And the blackmailing was coming from people who had access to public birth records, and they would use those public birth records and go to the adoptive parent and threaten to tell the child that they were adopted. And that was used as blackmail for those parents. So immediately this became an issue of sealing records and making them unavailable even to the adopted person later. New York followed the following year in 1936, although now it's unrestricted. And generally over the years, the three reasons really to seal birth records and make them unavailable were, one, to facilitate the strengthening the adoptive family. So free from interference, generally from the birth parent. So it was not more about interfering with the birth parent from the adoptee. It was more about keeping the birth parent, whether this is, a myth or not, keeping the birth parent away from the adoptive family. And two, so that's really the main reason why they were sealed back in the day. Now, over the years, there are all sorts of issues that came up. So like as the market in adoption, it really was a market and still is, developed, agencies were making promises of absolute confidentiality as a marketing tool to have their social workers work with adoptive or biological parents. And that's where this whole myth of the promise of absolute secrecy arose from, is the private adoption agencies using it as a marketing tool to facilitate adoptions. And I think it got set over or laid over. The original purpose was to protect the adoptive family from interference. And so, even the National Vital Records Administration in the 1950s said that the adoptee should always have access to the record, even at age 18. And so it wasn't a vital records issue. It was more an adoption agency issue to facilitate adoptions and make them confidential. There's no real straightforward answer on that. And that's why I think we're always dealing with these myths floating around, and you can grab onto one or grab onto another.
And in the states that, I'm looking at New Hampshire, 2005, Maine, 2008, did they have a number of years for implementation? Did they, retroactive, prospective, how did that work?
So in both of those states, I can't remember the time frame they had once it was enacted. Typically in a state, if you're changing the policy fairly significantly, let's take Vermont. If they change their policy significantly, there would be a period of time in which you would allocate some funds to do a public awareness campaign to say this change is coming. If if there's an option for a birth parent to do something about it, they would have the time to do that. And so typically in those states that have changed their policies and made it unrestricted, there's been a time frame to allow people to get used to that, and as well as a public awareness scheme. But they were always what we call retroactive. I mean, these unrestricted states would say all adoptions in the state are now, the adoptee can request the birth record and receive it, a few weeks later after paying the nominal fee. You run into issues in some states where you have disclosure vetoes in the past, and what are you going to do with those? Those are the hardest ones.
Yeah, in terms of opposition in those states, and was there, stated need for funding, in terms of departments of health or?
So the cost typically, the public awareness cost generally isn't large. The cost may be if you're adding additional documents that are filed. So for instance, if you do have a contact preference form, there is a fiscal cost with possibly hiring someone to handle those. You're not going to get a lot of them. You don't get a lot of the, the registry probably doesn't get a lot of them either, but you don't get a lot of the contact preference forms filed for any number of reasons. But the fiscal cost should be neutral if it's only about releasing the birth record, because the Department of Health charges a fee for the record, and that should typically cover the cost of processing. Opposition, the opposition, if I were to sum it up, it would be often sometimes it's major adoption agencies, although they've changed their tune more or less, and have not so much given up on the issue, but have said this is an issue that we no longer feel the need to oppose. Even the National Council for Adoption doesn't actively oppose it. And even the Academy of Adoption Attorneys has a resolution now that very specifically supports the release of the records to the adopted person at age 18. So the opposition is fading, but you have strong pockets depending upon what the politics are in the state.
Sure.
Yeah, just wondering what the fees are in other states.
So we typically,
And not a question for you, but in general for the committee, it's would the corresponding department set the fee? But
I mean, if you're to ask me that question, the fees vary. We try to keep them similar, if not the same, as what other people pay to get their birth record. In some states, it may be a little bit higher. In Connecticut, who just made their entire state unrestricted, I think it's $65, where someone in the state who is not adopted would pay maybe 25 to 30. But they're either very similar or not much more. And that's driven by fiscal cost as well.
sure, great, thank you. And I guess for you, Madam Chair, would the department set that fee?
Department of Health,
Yeah.
I think so, but I think that's a better question for our next witness.
Oh, okay.
But I see go ahead. I see you're nodding your head. So if you want to, Christina, welcome. If you want to identify yourself and answer this question, and then we'll go back to Mr. Lewis. Okay, go ahead.
Sure. My name is Christina Schuma, and I am the Vermont Adoption Registry Coordinator. And the way that original birth certificates are provided to adopted individuals after the release has been approved through the registry or through the courts, or for those that were born after July 1st, 1986, and there's not a non-disclosure, the Department of Health does provide an informational copy. So it doesn't come on the Vermont paper, and it's not a certified copy of the decree or a certified copy of the birth certificate. And my understanding has been that they do not charge a fee for the non-certified copy of the birth certificate. And I think most folks probably know that I believe it's $15 for birth certificates with the certification for people that were not adopted individuals who are getting their birth certificate with their legal name on it is, I believe, a charge of $15. So we don't charge a lot. And I don't know if the Department of Health would want to reconsider that if they are to now provide original birth certificates. I know I took a look at Mr. Lewis's documents, and that New York State had, I think, was it 20,000 within the first couple of years of requests. Granted, we are not that big, but we also don't have that many staff either doing this.
So does that $15 cover the cost?
I'm not a Department of Health employee, but my understanding is that the $15 is the flat fee that they charge for birth certificates, vital records in Vermont.
Thank you.
So back to you, Mr. Luce. In other states, I think you said that New York had did a study committee or something like that. Is that generally the way it goes, or because, for instance, we do public hearings during our session. We do have study committees, but we're just curious about how other states have done it.
I wish sometimes we'd have more of those, because we would have more voice and control in the issue itself. Often these bills just pop up, and suddenly we're either fighting them or saying, yeah, it looks like a good bill. And often they're constituent driven. So it's a constituent who's come to a senator or a representative and said, hey, I have this issue, I can't get my birth record, or whatever the issue may be. And that bill is drafted without a lot of, multi-party input. And then we're left trying to deal with that bill. So I think I would often prefer a study group if it's very serious about looking at the issue and being creative and coming up with something that does preserve the right of the adopted people to get their record. But you kind of are doing that right now, it seems, with these hearings. It's an interesting exercise to see how your committee works and are taking this very seriously. So I would say that it's a minority of states that would do a study group, although I tend to think they're a good idea, and that helped quite a bit in New York.
Thank you. And if we were to do a study group, who would you like to see on it? I don't mean actual names, but who in terms of,
Oh, we always insist on having Vermont-born adopted people, those who are impacted by the bill. Often it is good to have a birth parent involved, and we certainly can recommend, or you can find birth parents who are interested in this issue. You're going to find that the vast majority of birth parents are very supportive of this issue, actually. So I think you'll find it very difficult to find those who oppose it. The Department of Health would need a representative there if you're talking only about the vital record. Ms. Schuma would probably be a good person to be on that as well, because she has experience in dealing with this communication and the issue and what the registry currently does. So I think you could find plenty of people who are interested, although we always insist that it should be those who are directly impacted by the bill or by the issue. And there are, I found out in getting involved in Vermont, there are quite a few Vermont constituents or adoptees that are very much involved, and you'll hear from some of them tomorrow.
thank you. Any questions? Anybody else? Yeah, sure. Yeah.
Yeah, no, I'm just getting a kick out of it in a sense, because I gotta believe, Gregory, that you're probably not usually asked questions like this about, study committees and who you want on it.
Right, I'm not. It's refreshing, actually. It's how I actually mythologize Vermont as well. So maybe I.
Yeah, so obviously I'm still kind of blown away by other states as far as this topic goes.
And there's always a balance of doing our work here in committee and feeling like we're hearing from enough voices and being deliberative, and not rushing, or not acting soon enough. Because I imagine there are folks out there that to hear a study committee and we're talking, this is second year biennium, so a whole new legislature next year. We're talking at least 3 years or a while before anything could happen. So just a consideration we need to think about as we do our work and we hear from more witnesses, and also if a bill that, let's say, opened it up or whatever, and we if we did a bill that we all could support and went to the House, it then goes to the Senate. So we have a whole nother body here in Vermont to look at the issue.
And could I add that the Senate has a current bill very different from this one that tries to consolidate all adoption records in the state into one central location. So it's a massive bill, actually.
Right. And I think that might be Senator Pearson's bill. Right. And I think this would travel alone, I would think.
Right.
But I'm not,
very different. Yeah.
I'm not familiar with that bill. But I've heard about it. But okay. Well, thank you. Thank you very much. I really appreciate your testimony. Thank you.
I appreciate being able to talk. Thanks.
Yeah, great. Thanks. Okay. Shuma, good afternoon. Thank you so much.
Very happy to be here again. Answer some additional questions I think came up from the last time I was here.
Yes. Thank you. So go ahead.
All right. So the questions that were posed to me that came out of that last meeting was about the Department of Health and how the Vermont Adoption Registry and the Department of Health interact. I can only speak to what the registry does after the adoption has been finalized. And if the release of information has been signed. So if we have a consent for disclosure from birth parents on file, and the adoptee has also provided us the consent and the request for information, and the registry can then therefore release the information to the parties. I'm also informing the Department of Health that the original birth certificate can now be provided to the adopted person upon their request. So I'll send them a notification letting them know that this information has been released by the registry, and I'm providing information to the adopted person about what to do to request the informational copy of their original birth certificate from the Department of Health and how that can happen. The person that I work with mostly on this is Jean DeSalle, and she is the Vital Statistics program supervisor over there. I believe that she focuses a lot of her time on issuing birth records for adopted individuals. Mostly after the adoption has been finalized and a new certificate is issued at the request of the adopted family. Does that answer the question that was out there, hanging out there about how we interact with Department of Health on this issue?
Yeah, it does. And also listening to the testimony today, I don't know if you do have anything to add, and I'm thinking about implementation. If we were to pass a law that would open everything up similar to surrounding states, what that would look like in Vermont.
Well, after we had our conversation last week, one of the things that I was thinking about was that I think we talked about reaching out to each individual birth parent to let them know that the statute has changed. And at that point, providing them with the information about the change of statute and the information about how they can sign the non-disclosure agreement doesn't substantively change the work that I do right now. A lot of times, if I'm getting a request from an adopted person and the probate court has authorized me to do a search to try and find the birth parents to understand whether or not they want their information released, they can still veto that authorization by giving them the information at that time. So I don't know, I was just trying to think about how does that change, how would this statute change the work that I do? And if it was a 1-for-1, every time someone signed a consent form or made the inquiry from the adopted person's side, if I'm still required to reach out to that birth parent to let them know that I'm going to do this because the law says I can do it, unless you provide me with a non-disclosure agreement, it's not going to be all that different. If we do the public campaign, I think that was, that was one of the other questions that we had come up about the implementation, is the public notice for statutory change. I don't think there's anybody that's at the state Department of Children and Families that was working in that capacity in 1996. So we don't necessarily have the institutional knowledge from the implementation side of it. I do know that there are some adoption agencies or other persons that were affiliated with that original process that might be able to inform what happened back then for the information change, the public notification piece. But it's going to look a lot different now than it would in 1996. And I know that the statute states using the internet, and I was thinking back to what was happening in 1996, and I know that I was just starting off in my work as a social worker, and the amount of access that I had to a computer back then was pretty minimal, and as opposed to what it is right now. So I think that the notification is going to look very different. And I think that we would actually reach more people utilizing a public campaign than ever before. But I'm sure that there are always going to be people that aren't paying attention to what changes, and our best efforts we're still going to miss people along the way. And I know that and that's not seriously any different than what I'm doing now, because I can't always find people because they move, pass away, names change, and never really know how to make contact with all the people that I could possibly be in contact with. So that is being discussed within Commissioner Brown's office, how to make that public notification piece, how to implement that. Right now, we have two systems, database systems for tracking adoptions that have occurred in the state of Vermont since 1940. That's what the adoption registry started tracking adoptions in Vermont. We have approximately 24,000 individuals in our electronic database. The paper database has not been fully implemented into the electronic database. So I would have to assume that there's at least a couple thousand more adoptions that are not in our electronic database. And it doesn't include adoptions that occurred prior to 1940. So I don't know what that number would be in totality at this point. Okay, I think those were all.
Yeah, thank you. I'm gonna Barbara and then Kate.
So Christine, I think you just answered one of my questions, which was like a ballpark number. Like, are we talking 10,000? We're not probably talking, no.
No, I'm guessing somewhere upwards of, got to be over 30,000 at least, if not.
Wow.
In that.
Total, not from 1940 to 1975.
Oh, total. Yes, I'm including all adoptions that have occurred since 1986 as well. They're all in our electronic database.
Okay.
In that 24,000 number in our electronic database is all adoptions that we've been doing probably since the database was initiated in the late 90s, I think. It was before I started working here, so it's a pretty rough database.
And have there been, I know you get to speak with a lot of adoptees and birth families. And I know that great sort of sensitivity happens in terms of caller ID number and letters head. And I get Attorney Luce's point that, we don't hear of, people's lives necessarily being ruined as a result of this information coming out. But I just wondered if that's sort of your experience as well, is that it's hard when sometimes people have, get contacted without their permission. And again, not usually, that's their own sleuthing or, whatever. But I just feel like you have heard so much that I would just love to hear your view on that balance.
Thank you. It is definitely a balance, and trying to reach out to birth parents to be sensitive to what their experience was and what they anticipate their future lives to be like. I can maybe count on less than one hand the number of times I've had a birth parent either yell at me and say, "Why are you calling me? Don't ever do this. I have no idea what you're talking about. And don't ever call this number ever again." That does not happen on a regular basis. And I think I have only heard of one person ever calling me and saying, "Hey, this person found me. Why are they contacting me?" And whether or not they were upset that they were found, or if they were just shocked at the fact that they were found. I think the one piece that is going to be missing throughout, unfortunately, is biological fathers, because they're not always on the birth records, which is unfortunate. And sometimes they're in the adoption records, but not routinely, and they're not always in the court records.
And my recollection is that back in the day, a lot of people were given the last name Lund, for example. So I'm wondering, I'm assuming maybe their last name was Catholic if they were born at Vermont Catholic Church. I mean, I don't know, what the code was, but getting the birth certificate doesn't necessarily give them identity info, right? Like,
No, I think that if they were named baby child Lund, that was maybe the name that was given to the child, but the birth parent information has been accurate. But the stories that I've heard about the fact that doctors would not write down the birth father's name, even if a birth mother told it, that does not surprise me. I rarely get a copy of an original birth certificate that has the birth father name on it, which is rather unfortunate, but unfortunately a truth in this work.
and the safe haven question doesn't, like, that wasn't.
I don't have the data on the safe havens in the state of Vermont, but I think that society has changed so significantly since the time that adoption secrecy was being promoted. I wouldn't imagine that would be, we would see a dramatic increase in baby safe havens in the future.
Thank you.
Right, yeah, the safe haven, that was out of fear of prosecution. We were working on it. Yeah. Huh. I think Kate, did you have
Yeah, I did have, I wasn't sure. I don't know if you're prepared to comment on this, Christina, but just in the testimony, this mention of the potential of a contact preference form, like if it were to sort of move in a different direction and this were to be something that we were to look at. I just didn't know if you had any initial reactions to that or how that might impact your work.
I'm not familiar with the contact preference forms. I'd love to get a chance to take a look at what the other states are doing. And I think when I was looking at Mr. Luce's documents, it is something that goes along with the original birth certificates or a vital record. It's not necessarily part of the search and reunion work or the adoption registry work. I think the question would be going forward, I mean, we can absolutely, if this goes forward as part of the statutory change, add that in with the original birth certificate. And if it gets changed, it gets attached to it. Again, going backwards, it would probably be a similar process of the public notification piece. So that way they could sign their preference to go along with the original birth certificate, as opposed to a non-disclosure through the adoption registry.
If I could just intervene real quick.
Sure.
Yeah, Ms. Schuma's correct. The states that do the contact preference form, it is filed with the Department of Health vital statistics, and then it is attached to the original birth record if a contact preference form has been filed, and accompanies the birth record when it's sent out to the adopted person. So they have that information when they receive the record.
Thank you.
Can I ask a question about that though?
Sure.
Has that been a provision for current and future, or is that something that has been provided to birth parents all along, or was it again notification to let birth parents know that they can sign this form that goes along with the birth certificate after the fact.
It is available to any birth parent who wishes to file it, no matter the year of the birth or the year of the adoption. And if you do have a database of birth parents in the registry, that would be a vehicle to send these contact preference forms out, so that they can then file them with, or notifications, so they can file them with the Department of Health.
Yeah, thank you.
Oh, that's interesting. Ken,
Thank you. So I could be confusing myself, but somewhere I've always heard 1986 for a date. And then a couple times today, I've heard 1996, unless my hearing is bad, which could be. But has anybody else heard 96? Are we using 96 too?
96 is when the law was changed. It was retroactive to July 1st, 1986. That was the line of demarcation for anyone prior to July 1st, 1986. Birth parents can either have to provide consent for the adoption registry to release that information. For all those adopted after July 1st, 1986, then as long as there's not a non-disclosure on file anywhere, the registry can therefore release the identifying information about the birth parents. The 96 is when the law was changed and when we started to let people know what the difference between the pre-86, post-86 law was.
Gotcha. Thank you for that clarification. Or
anybody else? For our two witnesses, anything else before we adjourn for the day?
I had one more follow-up from our last conversation.
Great.
And it was about the question of the definitions of the probate and the agents, or the court and the agency in the law as it was proposed. I took a look at the definitions section again of Title 15A, and there it does specify that court means probate division of the Superior Court wherever court is mentioned, and an agency includes the Vermont Adoption Registry and any private adoption agency. I am satisfied if that remains the same. I just was confused when I saw that it was probate specified in the statute that I read on a regular basis, and how it was different after 1986, which I have no idea why they specified before 1986 and they didn't specify after 1986. And I think I was listening to Mr. Hughes last Friday in his testimony that he stated that the agency should only be the adoption registry. I would counter that we still need to have it as agency inclusive of the private adoption agencies that are still in business, because I don't have access to all of their records. Children's Aid Society closed several years ago, and we inherited all of their records, but Lund is still an open agency. Vermont Catholic Charities still has their own adoption records. They're no longer, I don't think they're longer a child placing agency, but they still have their adoption records, and I don't have them in the registry. So they may still have disclosures and consent forms on file that we would need to have access to.
Thank you. That's helpful. Okay. Any questions after hearing those two follow-ups? No. Mr. Luce, anything before we adjourn?
No, I'm encouraged by the thought that you're giving this bill. and how complicated it actually is to try to figure out to do the best thing. My only concern is that you concentrate on what really matters to adopted people, and that's the original birth record. And what they do with it is up to them.
Great, well, thank you. And so right now we have a bill scheduled again for tomorrow afternoon, and then after tomorrow afternoon, we'll talk as a committee and hear from the witnesses and see where we go from there. But here in Vermont, we have something called crossover, which is the date by when we as a House need to get our bills out of committee, right, and onto the floor. And it's March 11th. And we have a break in between. So we have, 1 or 2 more weeks or so where we can continue to work on this. So just want to emphasize that today or tomorrow are not necessarily our last days on this issue.